Good day. My name is Chuck Dick. I have the privilege of being a co-chair of the programming committee for California Arbitration, and one of my special treats is the ability to serve as a host of our California Conversations series. And today we have a most interesting guest, and I've really been looking forward to an opportunity to introduce you, our viewing audience, to one of our colleagues in California, Jerry Roth, who has a really remarkable background and career and is in many ways an example for us to emulate as we look at establishing our own careers in this burgeoning field of international commercial arbitration. So, Jerry Roth, welcome to California Conversations. It's great to have you with us today.
Thanks so much. I'm delighted to be here. Really appreciate it.
Well, I can't help beginning this conversation with you by remarking about your very impressive academic record, which ends up in with a federal clerkship. You then find your way to the Eastern District of New York as an assistant United States attorney, prosecuting bad guys, and all of that has the hallmarks of aiming you for a career in the courtroom and as a trial lawyer. I know that was part of how you got started, but tell us a little bit about that experience and how it positioned you to become who you are today.
Well, thanks so much, Chuck. Yeah, so I went to Harvard undergrad, Harvard Law School, originally from Brooklyn. And after a few years practicing at large firms in New York, I ended up at the Eastern District of New York, U.S. Attorney's Office, which I consider the best 5 years of my professional life and maybe my personal life. It was a really fabulous experience. I started handling drug prosecutions, a lot of drug prosecutions in the Eastern District out of Kennedy Airport for importation of various narcotics, but moved from that into white collar and ended up prosecuting a bunch of fraud cases, including against lawyers, against politicians, a number of financial crimes cases, and of course, tried case after case, which I think we used to do more in the old days. I hear from current AUSAs, they are sometimes frustrated that more cases don't go to trial, but our cases did. And so that was, of course, fabulous experience for preparing me for working at a firm.
Well, you then find your way to really not just a firm, but Munger, Tolles and Olson was a firm with legendary reputation. And did you come out to the West Coast to continue your practice in white collar crime, or explain that
So
a
I
little?
had clerked for a judge in San Francisco kind of on a whim. I had this dream of San Francisco as a Brooklyn kid, as a wonderful fantasy city. And I had a really, really great experience living out here in 1983, 84, and clerking for Judge William Schwarzer, who recently passed away, but who I consider a hero and a mentor and just a wonderful member of the judiciary. And I went back to New York after clerking and just had a bug that I loved San Francisco and had to find a way to get back. So after I got out of the U.S. Attorney's Office in 1991, I looked at a number of firms in Washington and New York. And then I looked at one in San Francisco. And within, I don't know, the first interview, I decided this was where I wanted to be. It was the old McCutcheon firm. You may remember it, McCutcheon Doyle, one of the great firms of San Francisco. And it had been around for about 100 years. And I spent about 3 or 4 wonderful years there practicing, and then was approached by Munger Tolles, which was looking to set up its San Francisco office. And it had set an office up with an environmental practice, but was looking for a litigator. So I had heard about Munger Tolles my whole life, and was very, very excited with that proposition. So I met with them, was very excited by the people I met, many of whom are still good friends and colleagues, and ended up going to Munger in 1995.
Well, you mentioned your clerkship with Judge Schwarzer. I wonder if you could share with us some of the really valuable professional lessons
Oh.
you learned from that experience.
Well, you may recall Judge Schwarzer was just an extraordinary jurist. In addition to sitting on the bench for many 30 or 40 years, he was the head of the Federal Judicial Center. He had very strong ideas about how federal litigation should be run. He was an activist judge in the sense that he believed it was the judge's obligation to move the case along, to be very involved with the procedural aspects of the case and make sure that it didn't sort of drift away if lawyers were not paying attention to it. He would start each case with a very active kind of case conference, which was not just a rote going through the typical categories that are in every judge's case conference statement requirement, but rather really delved into the case about whether there were issues that could be resolved early. That was a very big question for him, and how the case could be brought to a speedy, efficient, and just conclusion as quickly as possible. And boy, do I think about those lessons in arbitration. His case conferences are sort of front of mind whenever I am involved in an initial conference in an arbitration or frankly, any litigation. He was also one of the very, very strong proponents of Rule 11 sanctions. If you recall, he actually strongly believed that the ethical obligations of lawyers were very high and were the basis of the justice system. And he felt that where lawyers intentionally ignored their ethical obligations, he thought there needed to be a sanctioned process. And I remember as a young lawyer finding an important case that one of the counsel in one of our cases had not cited, even though it was clearly significant precedent. And one of Judge Schwarzer's strong beliefs was that it was a real obligation of lawyers to bring to the attention of the court precedent that went against them, and that was, binding precedent or even significant precedent in any case. And I remember his taking my memo, my bench memo, which mentioned the fact that this case had not been cited by one side and it hurt their position, even though it was kind of the preeminent case in the area. And in the middle of the hearing on this issue, holding up my memo like some kind of prop, saying, "Sir, did you know about this case that you did not cite that controls this issue?" And I just remember the courtroom freezing at this moment, and the lawyer freezing. And he actually ended up imposing sanctions on the lawyer for not having cited this case that I had stumbled upon. That experience, the look on that lawyer's face, the feeling in that courtroom have lived with me to this day. That would have been 1983. So I don't know, some 40 years later, I can remember the chill in my body when that happened. And it certainly has motivated me, reinforced my belief in the importance of legal ethics and making sure that you are fully transparent and upfront with the court, including about aspects of the case that are unfavorable. So he had an influence on me that I can't even begin to fully describe. His case management and his belief in lawyer ethics are the two things that really stand out now, all these years later. And I miss him terribly.
Well, you went on from there to have a distinguished record as a white collar criminal defense lawyer. I guess I should say even more broadly, in terms of courtroom advocacy, you made quite a mark for yourself. And during the course of all of that, you surely learned some things about yourself, about your own interests and what you were called to do. And I appreciate you sharing those lessons with us as well.
So thank you. That's a first of all, I appreciate all the nice things you're saying, and I do feel like there were lessons from early years as a prosecutor, and then the transition to the defense lawyer, and actually important lessons from the very act of the transition. Um, when I was a prosecutor, and it's significant to me today as we sit here because I'm reading about everything going on in the Southern District and at the Department of Justice. Um, Judge Schwarzer's lessons about being upfront with the court really resonated. But I was a theater guy as a kid. That was my thing in high school. I starred in school plays and I loved to perform on stage. And I always felt that I learned when I went into the courtroom as an AUSA that in many ways it was theater, and it brought back those memories. You have so many eyes on you, watching every aspect of what you're doing, watching your reaction to what other people are doing, watching how you respond if somebody asks you for a document or a favor in the court, how you respond to something surprising that occurs in court, how you respond to being chastised by the court about a question or an answer. Um, and that very much sticks with me, the notion that there is an aspect of courtroom, of trial procedure that is theatrical with the overlay of ethics. So I remember very much thinking about that sort of balance. How do you act in front of a jury so that they see and get your points, but make sure you maintain full respect for your obligations, and in that case as a prosecutor and later on as a defense lawyer, to your obligations as a lawyer. They're sometimes in conflict. An actor can really go overboard in making a point or in emoting. As a prosecutor and later as a defense lawyer, you want to think about what your obligations are to the truth and to the court process. But Chuck, the biggest thing I learned, I would say, is the transition from prosecuting to defense lawyering, because I felt as a prosecutor that things were black and white. I remember feeling when I was prosecuting a case that the defendant was the bad guy and I was the good guy representing the United States of America, one of the proudest things I would say at the beginning of every jury argument. I kind of saw the world as black and white in the sense that the defendant had done something wrong and deserved to be punished for it. And I think that is a mindset we may want our prosecutors to have so that they handle the case zealously, of course, always within the bounds of appropriate ethical behavior. When I became a defense lawyer and started meeting with these very same defendants, often in white-collar cases, I will never forget the change in my view. My view suddenly became that this was a full person who had so many wonderful aspects about him or her. Most of my defendants were him, sometimes hers, who had a full, rich life. And this conduct that he had engaged in was only a small part of it. And I began to see everything in grays and colors. And that has continued to this day, both personally and professionally. I think it helps you to try to sort of think about where is the other side coming from? Where are both sides coming from if you're in a judicial or arbitral role? But even as a party, where is the other side coming from? And it goes back to that transitional moment when I started realizing that these defendants had their own story, had their own background, had their own reasons. I often used to say they made momentary decisions that reflected bad judgment, but that affected the rest of their lives. But aside from those momentary bad decisions, they had full lives that made them full people. So that's, if I had to pick one lesson, that's my lesson, and I kind of think about it a lot.
Well, your practice now has begun to migrate in the direction of arbitration on an international level. And I
Yeah.
want to talk a little bit more about that. But
Yeah.
tell me how this transition came about, and how share some experiences with us that might enable those who are aspiring to do the same thing to learn from you.
Yeah. Well, thanks. So over the course of being a young lawyer, often handling litigation and white collar cases, I started to realize that the cases that really that I felt most passionate about had some international aspect to them. They either involved facts that occurred in a different country or parties that were not U.S. based. They involved different bodies of law outside the United States. And I just found that fascinating, how the interaction of US and foreign law, the role of how a party who's from another country finds him or herself in the United States interacting with US companies or individuals, and vice versa. And I started to migrate towards those cases. I also, as a kid, loved foreign language, and my favorite subjects were Spanish. And when I was 15, I asked my parents to send me to France for the summer to live with a French family, though I spoke no French, to try to learn French. And when I was in college, I wrote my thesis in Italy, and I studied German and Russian in college, and then continued my language studies in law school. And I realized there was a synergy between that love of foreign language and the related cultures of the countries whose languages I was studying, and this interest in international law. And the more I sort of tried to combine them, the more satisfied I was as a lawyer. And I started to find cases that were purely US based, I was less passionate about them. And I felt that it was important for me to pursue that interest. And so in 2008, after I had been a partner at Munger Tolles for about a decade, or actually, yeah, a little more than a decade, they had a fabulous program where you could take a sabbatical for up to a year as long as you did something that advanced your career. You could take 3 months and ride on a beach and sit at a cafe, but if you wanted the full year, you needed to do something that would benefit your career and the firm. And so I applied for that program, and was given the privilege of taking a sabbatical for a year. And I applied to several universities in France to get an LLM, and got admitted by the University of Paris, Paris 2, which is sort of one of the branches of the former Sorbonne in Paris, for a year-long program about French, European, and international business law. And went there for the year and had a absolutely magical experience studying French law in Paris for the year. And that clinched it. When I came back, that was what all aspects of international law, arbitration and transnational litigation, was where I wanted to focus my attention.
Well, you obviously have a natural facility for foreign languages. You are as multilingual as anybody I've encountered, and it comes so naturally to you. But I wonder if you'd share with us a little bit on a deeper level what's been the significance of having that capacity as you look at representing your clients, participating in the international dispute resolution process, and being an advocate with this kind of gift of language capacity.
Well, you know, I I sometimes feel that U.S. lawyers and the Americans generally, but U.S. lawyers in this context, can feel that, and in many ways, we there are aspects are the gold standard. What and folks are gravitating towards the U.S. legal system. They want to come to U.S. law schools. They want to be fluent in English, which has become the lingua franca, certainly in the legal profession, et cetera. Um, but I do think there's a risk that US lawyers can then be seen as not being sufficiently sensitive to the culture and language of the parties that the non-US parties that are involved in a case, whether it's as counsel or as an arbitrator, or I assume as a judge. Um, I don't want to say it's an arrogance, it's just an assumption because you're often working in English and the parties have ended up in something that is US based. But I find that being able to speak the language of parties and their counsel, and not necessarily perfectly, just showing that you have spent the time to at least have an understanding. If there's a foreign alphabet, for example, that can be learning the alphabet. If you can speak the language, at a conversational level, and of course, obviously, if you can speak it fluently, it changes the dynamic. I think it's so respectful to the other parties. It shows an openness, a willingness to recognize that English is not the beginning and end, the be all and end all, that the cultures of other countries are so important to the parties before, that you're working with or against, or as an arbitrator. And I have found that being able to make that connection with some acquaintance with the language and the culture of these parties is a game changer. It changes the dynamic in the room. And just to give you one example, I do not speak Korean, but when I was handling a case in Korea, I saw a book on a bookshelf at a like newsstand that said, "Learn the Korean alphabet in an hour." And I thought, how ridiculous is that? This is fraud, and I'm gonna prove it by buying this book and not learning the alphabet in an hour. And sure enough, it turns out that the Korean alphabet has 18 letters. It is a manufactured alphabet created specifically to be easy to learn, where the shapes of the letters mimic the shapes of your mouth as you are forming those letters. And you, Chuck, in an hour from now could learn the Korean alphabet quite easily. And what that now it's a little bit dangerous, right? Because all you can do is sound out the words in front of you. You have no idea. It's a very complex, beautiful language with levels and levels of subtlety in terms of the position of the people who are speaking it, the relative positions. There's several ways to say everything, depending on who is speaking to whom. It's quite complicated. But when I work with Korean parties, and I'm just using this as an example, and I'm able to read words or write their name or write my name in Korean figures, the sense of connection between me and these parties is enormous. Enormous. I don't think it can be matched. And it really creates an opening. And I find that in whatever language you want to refer to, having just enough to show that you cared, that you spent some time, that you put in the effort, that you understand that they have a rich, beautiful language and tradition, I think is invaluable. And it is, for me, I feel like it's been the basis of my international practice.
Well, this language must have been a springboard into the deeper culture itself and to help you, I guess, appreciate why people may have done particular things in the matter that you're now involved in. Uh,
Absolutely. I mean, understanding the language is the next step to understanding the culture. And you can't fully understand the culture without at least having some understanding of the language. Korean is a wonderful example. Just the aspect I just spoke about. The fact that there are all these different levels of ways in which to say things, depending on the relationship um, between the parties, reflects how Koreans live and interact, which is the position, the ties between the two people, relative positions, and other aspects or other connections will determine some of their interactions in ways that in the US would not be relevant. And so it's an insight um, into that. And I think that's replicated in every language I've dealt with.
well, your language skills and your, dare I say, curiosity about other cultures and learning and absorbing cultural experiences may be an explanation for how you've gotten so deeply involved in the International Association of Lawyers, the UIA. You were president of this organization, in fact, just a few years ago, and there are a lot of our viewers who may not even know about this. And I wonder if you could tell us a little bit about that story.
Oh, sure. Thank you. Yeah, I could talk about UIA forever, but I won't. So most folks are familiar with the IBA, which is based in London and is the largest international lawyers association. Great organization, huge, and very Anglo in the sense that most of their activity, if not all of it, is conducted in English. And it's, I don't want to say it's dominated by, but the US and the UK are certainly two of the principal players, let's say, if not the most principal players. The UIA is kind of the continental alternative. I think of it as the Avis to the IBA's Hertz, although the UIA is going to be celebrating its 100-year anniversary in 2027. It was founded in the wake of World War I with the idea that lawyers could help avoid the war that had occurred in World War I. And it has lasted and thrived over the past soon to be 100 years. Was originally founded in Belgium, but is now based in France. It is the European continent plays a critical role in it, is the principal player. South America, Mexico, the Spanish-speaking world, critically important, as well as French Africa, most of North Africa and Lusophone Africa, Portuguese-speaking Africa, and then and Asia. And a lot of this is because most of the countries in that are well represented in the UIA have civil law systems. Of course, that our common law system has not been a market success, let's put it that way. It is only the system of a small number of countries besides us in the UK. The civil law system dominates Europe, South America, Asia, and Africa, or at least certainly Northern Africa and French-speaking, Portuguese-speaking Africa. And so it is very present in all of those places. It puts on seminars during the year. It has a wonderful annual congress in a different city around the world. There are about 2,000 members at any one time, lawyers from all over the world. I became involved in 2002 because there was an investigation of a French company out of the U.S. Attorney's Office in San Francisco, and they needed a French-speaking criminal lawyer to represent this French-speaking executive. And there weren't a heck of a lot of them. So I got several calls. All of a sudden, my phone was buzzing from several different sources. And through the folks involved in that case, I became very involved with the UIA until I worked my way up to become its president in 2019. And through it, I have met not only lawyers around the world who have just taught me so much and such an impressive group, but also bar associations. It's very active among bar associations. And so through the UIA, I have had the honor of meeting sort of the leaders of bar associations around the world. Bar associations in many other countries, if I can say so, are more important than in the United States. The ABA, obviously plays a wonderful role. I'm a member in putting out statements, organizing educational events. But in many countries, the Bar Association has a real role in overseeing lawyers and being involved in the interaction between lawyers and the government, lawyers and their client. And the head of the bar is a seriously respected position. The French, for example, head of the bar, the bâtonnier, or if it's a woman, the bâtonnière, is a very well-known person in the legal community throughout France who has authority whenever there's issues about lawyers. I learned a lot about the role that the Bar Association can play in the country in maintaining integrity, in protecting the rule of law, in making sure that there's equal access to justice, all of those very important values. So the UIA has been a wonderful experience, and I continue to be very involved. We'll be having our Congress this year in Guadalajara, which is the cultural and in some sense a business capital of Mexico. Really looking forward to it in October of 2025. We're excited to be there on Dia de los Muertos. So we will be there on October 31st, November 1st. It'll be a real treat for everybody who attends. It's about 1,000 to 2,000 lawyers who come together for various main themes and then a series of seminars, cultural events, but mostly, interaction, learning from lawyers around the world about what's important to them, what advice they can give you, and having both professional and personal interchanges.
Well, it sounds to me as if your work with the UIA has been a window of sorts into the civil law jurisdictions and given you some special insights there. And I wonder if you could discuss with us just a little bit what importance you would attach to that and having a better understanding of this dramatically different approach to the legal systems of the world.
So, I learned so much about the differences between our system and the civil law system during my year studying in Paris, and it has been reinforced in the cases I've handled, as well as my interaction with lawyers through the UIA. It's a really interesting question because I feel that the two systems are dramatically different and yet often end up in the same place, getting there in two completely different ways with two different mindsets. I also think that the systems are slowly, maybe imperceptibly, but when you take a step back, clearly coming together a little bit. And I have read quite a lot indicating that maybe in part due to international arbitration, which takes account of both systems and brings them together in many cases. So issues like contract interpretation, use of precedent, cross-examination, witness preparation, even very American things like discovery, which is not well received around the world. There's a slight coming together of the two systems. But the key difference is that we are a precedential system. We are in the common law. We're based on prior cases. The civil system is based primarily, as we know, on code language, the statutes, but also how they're interpreted by courts, by academics, by commentators, and all of that comes together to form what's called jurisprudence, which has a very specific and different sense in many European, South American, Asian cultures. It's kind of the bringing together of academic thought, cases by the Supreme Court of the various countries on the particular codes. And so the jurisprudence and common law can start to coalesce in that sense, because it's not use of precedent. It's not saying that this case controls the next case, or we look to this case to decide how this case is different. But it has struck me that there are similarities that are growing as the world has become more interconnected, and as international arbitration has had to grapple with both systems. The only other thing I'm going to mention, because it's so topical, I am fascinated by the fact that in the United States, we have an executive branch that is the only branch that can investigate and prosecute crimes. And that includes of the executive crimes committed by the executive branch, for example. So that has given rise to a series of norms, but also a series of issues that we are confronting on a daily basis in our country. In France, for example, and in the civil law system in many countries, on the criminal side, that very problem was noted, that if the entire prosecution and investigative function is based inside the executive, what happens when it's the executive that's at issue? And partly in response to that, and partly as part of their system, they have taken a chunk of the investigative power and given it to the judiciary. And that gives rise to this different function that we don't have, called investigating magistrates, who can investigate crimes as under the judiciary, not answerable to the executive. Very different. If you think about how that would apply in our country over the past 10, 15, 20 years, it's a fascinating question. And that system has developed many problems that the French debate, and that I've certainly spent a great deal of late nights talking about with my French colleagues. But those are just two examples of differences that I find not only interesting, but that help you think about our own system and how our system works.
Well, those of us who are smitten with the City of Lights and just the charm of Paris have to be a bit envious of the fact that you have the ability to live part of the year in Paris. And quite apart from whatever charms may have attracted you to do that, that has to have an impact on your professional life as well. So tell us a little bit about being a lawyer who's living in France.
Yeah, so I got a place in Paris because I was going to be the president of UIA, which is based in Paris, for the year. COVID interfered, as it did. I can't complain too much, but because it interfered with others in a much worse way, but it interfered in my year. But I kept the place, and I have spent a great deal of time in Paris interacting with the French bar and my French colleagues, as well as, just throw this in, the family that I actually did an exchange with when I was 15 years old, I'm still very close to. They live in the middle of France. They're not big fans of Paris, but to see me, they'll come up from time to time, and that's an important part of my time there as well. My French brother, Jean-Paul, who I've known since 1974. But
Oh, what a joy.
yeah, it is a joy. It's a very special, has been very special for me.
Well,
But
notwithstanding that, you do come back to San Francisco,
yeah,
which has some charms of its own. And let me just use that as a segue to ask you a little bit about your musings about the future of our profession, and particularly here in California, how commercial arbitration is really just at a point of burgeoning.
so I think it's the most exciting thing going on right now in two things are exciting to me right now. Opera in San Francisco, because I'm involved in the opera world, and arbitration in San Francisco, because I'm involved in the arbitration world. And in arbitration, um, California has enormous potential, and it is just getting started as an arbitration seat and a source of arbitrators as well as arbitral counsel. It is, as you know, there's a new association, relatively new association of California arbitrators. There are efforts. There was a recent change in the California law statute book to allow international arbitrators to sit in San Francisco or in California without being a member of the California bar, as most jurisdictions permit. We are on the verge, in my mind, of something very big and very exciting. And California appeals to people around the world in part because of its physical beauty, and it has always been obviously a tourist center. But I think, and what I hear, is that it is also seen as a little bit more open, um, a little bit more less US focused and more open to the world. We have an incredibly diverse community in California from all over the world. And we also we don't come burdened with the history of the past, the history that much of the East Coast, and I say this as a Brooklyn boy, comes burdened with. So I think we're perceived as open to other cultures and to other legal systems. We're seen as, because of the diversity, having all the resources that we need for an international practice. We are well positioned close to South America, to Mexico, as well as obviously to Asia. But Europeans, if you ask a European what their favorite city is in the US, they may well say San Francisco. And that's because, again, there's this, I don't know, some kind of affinity that people around the world, and in Europe in particular, do have for the city and for the state. And so I think all of that comes together, this openness, this willingness to hear and understand legal systems from around the world, the beauty and all of the attractions of California, California's decision to sort of be open for business in this area, and the steps it has taken to do that, the excellent lawyers that practice here, the extraordinary judiciary that we have. I think this is a moment. I think it's a very significant moment in the ADR world, and I think California is just getting started.
Well, what a positive note on which to end this interview. Jerry Roth, this has been as fascinating as I imagined it might be. I really want to thank you for taking the time to be part of California Conversations, to share a little bit about your story, about yourself, about your values and your experiences for those who are coming along as the next generation of practitioners, not just in California, but in the United States, to be sure. So please accept my gratitude, the gratitude of California Arbitrations for your time. And it's been a delight to get to know you a little bit better and to share these experiences with our viewers.
Thanks so much, Chuck. I
We're in your
really
debt, Jerry.
appreciated
Thank you
it.
very much.
Really a pleasure.